Thank you very much. It's a great pleasure to be here, and I really appreciate the invitation to be here and speak to you today. I'm in the unfortunate position of having to apologise for both my Spanish and my English, but I will persist. So today I'm going to speak about procedural, evidentiary and policy issues. I'm going to undertake an historical and comparative study. It's comparative across jurisdictions and also across knowledge traditions. It's based on fingerprint evidence, but I think it has wider implications for other forensic science and medicine, and also for other forms of expertise, and also for the use of expertise in non-common law jurisdictions. I'm going to tell a story, but I'm going to tell a story out of chronological order. I'm going to begin with the kind of scientific expose on latent fingerprint evidence, and then I'm going to give you an historical snapshot of a few episodes of common law courts in Australia, the United States, and England and Wales, and their responses to that evidence by way of comparison or contrast or juxtaposition. It's my contention that really, in looking at how fingerprint evidence came into courts, there were very few historical challenges. In terms of judicial management of the evidence, I'd say it's a kind of failure. And in terms of fingerprint evidence, I'd say it's a modest, serendipitous success story. Also, in terms of the outcome today, it's what the sociologists of science might call co-production. The fingerprint evidence is a kind of co-production of fingerprint examiners and lawyers and courts that was for most of its history separate from scientific knowledge and scientific research. I'm going to focus just on reported decisions. It's not my contention that there aren't lots of other cases and even earlier cases. I'm only talking about a few select reported cases. So these are cases that are often appealed and in the reports. And I think that's important for several reasons, partially because we don't know about the unreported cases. If there were fantastic challenges, well, no one ever refers to them or cites them. They've been lost, and that's an issue about institutional feedback and learning. And I'll say more about that later on. I also need to say it's not my contention that latent fingerprint evidence is unreliable, but quite contrary. They're genuinely experts, and that's kind of both fortunate and a good thing. Okay, so I'm going to start with, as I say, scientific knowledge, talk about common law origins, then modern admissibility regimes, and then after the kind of reports come out, what do the courts do? And that becomes interesting. And I'm going to start off just by saying a couple of things about latent fingerprints and latent fingerprint comparison, just so you kind of have an idea in case you don't know. So the first thing to say is that modern latent fingerprint examiners use a procedure or method called ACE-V. It's an acronym: analysis, comparison, evaluation and verification. Basically, an examiner works out whether the latent fingerprint they find at a crime scene is sufficient for analysis. If it is, then they undertake some kind of analysis of the actual fingerprint and find points. Then they compare those points with reference fingerprints. They undertake an evaluation. That's almost always a positive identification, often to the exclusion of all others. So they identify one person and one person alone in human history. And then it's often reviewed, but the review by another fingerprint examiner is very rarely blinded. So the fingerprint examiner who reviews knows the original result. Fingerprint examination is dependent and has been dependent upon two profound assumptions. One is that fingerprints are unique. This can't be tested. It's just a belief. It's fingerprint dogma, though there's no doubt that fingerprints are quite highly differentiated. And uniqueness is a bit of a misnomer, and I can talk about that in question times. The other thing is that fingerprints are permanent. That's less controversial. Most fingerprint examiners in the 100-year history or so have had no formal scientific training. They're police officers or investigators who have basically just had a kind of apprenticeship. When fingerprint examiners testify, they not only positively identify a person, but they have historically claimed that the method they use, ACE-V, is infallible, and that they're 100% certain in relation to their analysis. It's important to say that fingerprint interpretation is subjective, that the examiner is making the calls. They're actually doing the interpretation. They're doing the interpretation in their head. They make calls about sufficiency. There aren't really standards about whether a fingerprint is sufficient. They make calls about whether these things match and that therefore that there's an identification. The three kind of findings are match, non-match or inconclusive. And that's probably all I really need to say to go on. So that's what the latent fingerprint examiners do. They testify in positive terms about identification. But it's interesting to know from fairly recently what the kind of mainstream scientific community that became interested or attentive quite suddenly from about 2004, 2005 after the Mayfield misidentification and the Madrid train bombing. There were some reviews, and I'm going to talk about those reviews. I'm going to focus mainly on the National Academy of Sciences, or the NRC report, but there are four others. Most importantly, the NIST report, so that's an American report as well, from the National Institute of Standards and Technology on human factors. There's the PCAST report, which is Obama's President's Council of Advisors on Science and Technology, and most recently the AAAS, the American Association for the Advancement of Science. So these are reports on forensic science or just on fingerprints that have come out since 2009, and I have to say they were surprisingly critical. So I'm just going to give you a snapshot of the sorts of things that scientists, engineers, biomedical researchers and statisticians were saying to the courts in these interventions, these advice and recommendations for forensic scientists and the courts. The first thing they say is that the validation of techniques is essential. You have to formally evaluate these procedures. And that's kind of interesting. Validation tells you whether the technique works, how well it works, and in what conditions. And the interesting thing is that historically, and this is an interesting claim, it wasn't until 2009, in 2009 there had been no formal validation of fingerprint procedures and accuracy. They also found that this is general forensic sciences, not just fingerprints, that few of the scientific methods or methods that were used actually had developed adequate means of measuring or determining the accuracy and error. And the scientists are saying these things are essential. We need to determine the accuracy and error, and this was something that was suggested in the previous talk. Also, when it comes to standards, many of the practices don't have standards. Those that do have standards tend to be weak. They're often consensual basis rather than empirically determined. They're often vague. They're often not enforced. They're often not revealed through reports or discussed in questioning. And that poses a threat. Human factors. So we've heard a little bit about cognitive bias, but human factors also go along to physiological issues such as vision and fatigue. But this is interesting because human factors or cognitive biases have become a very important issue in the forensic sciences from these reports. And what we're finding out is it's not about, morality or personal attempts to kind of overcome them. You can't overcome most of them in most conditions. And yet most of the forensic sciences had not paid any attention to these risks. And I'll say more about the kind of information that fingerprint examiners had as well. Now, if we move on just to look at some of the more detailed or specific comments by the scientists on latent fingerprints. So this is what scientists are saying in 2009 and 2011 about the actual method, ACE-V, which many fingerprint examiners had testified as an infallible method. They're saying that ACE-V provides a broadly stated framework for conducting the ridge comparison, comparing the features of a fingerprint. However, it doesn't guard against bias. It's too broad to ensure repeatability and transparency. Doesn't guarantee that two analysts following it will obtain the same results. And it doesn't imply that one who's using it is proceeding in a scientific manner. In terms of terminology, the most recent report from the American Association for the Advancement of Science says Latent fingerprint examiners traditionally claim to be able to identify the source of a latent print with 100% accuracy. These claims were overstated and are now widely recognised as indefensible. It's interesting, in the President's Council's report, they actually reviewed all of the validation studies that existed as part of their review of 7 forensic sciences. So this is it. This is all the validation studies. You might look at the dates for the early studies for latent fingerprints from 2009. So, you know, these are people, scientists, who know about all of the studies that are available. They asked the fingerprint community to come in and provide all the information, all the scientific studies they had. This is what emerged. And it's interesting, and one of the interesting things that comes out of the serious kind of black box studies by Ullery and colleagues is that there are errors. Now, these studies, which are done close to the conditions of casework, where examiners can use their standard equipment, they're finding errors in the vicinity of maybe 1 in 600, depending on how you measure the errors or describe them, and maybe 1 in 18 or 24 in these studies. So this is not sounding like an infallible procedure. In terms of what fingerprint examiners should do, this is what the President's Council recommended. They said, you've kind of misled, and the Association for the Advancement of Science said the same sort of thing. You've misled, you've over-claimed for decades, and because of the jurors are likely to have, or fact finders are likely to have, an overvaluation or a misunderstanding of the actual value of fingerprint evidence, you need to report some indicative error rate. And we could talk about the propriety of applying this later on, but these are based on the only kind of genuine empirical studies that we have, and so these should be included in all reports that experts offer, in all testimony that they give in court. In terms of the human factors and cognitive biases, once upon a time, fingerprint examiners would know things often like the crimes that the suspect had committed. They might actually be told about the case by the examining police officer. They'd know lots and lots about the case when they're doing their comparison. And they weren't shielded from that. And people who reviewed the fingerprint examination, the verifier, wasn't blinded from the original result as part of the review. And now the advice is, in most situations, you should be very attentive to the dangers of cognitive bias, of suggestion, of confirmation bias, and so forth, and you should design procedures to eliminate the worst of these risks and study performance. And there's no reason that fingerprint examiners need to know about the prior history of a suspect. All they're doing is comparing 2 fingerprints. They don't need to know about the violent crime that was involved. They don't need to know any of it. The one kind of final thing I want to say just in relation to the advice from the courts is that the scientists who were attentive and started to look at this were surprised, and they couldn't help offering criticisms of the courts, particularly the United States courts, and they couldn't help telling the courts that the criteria and the kinds of proxies that lawyers and judges were using to make sense of expertise were genuinely or generally misinformed. So they would say things like, and these are the kinds of things that certainly judges and lawyers in the common law tradition rely upon, and I suspect that they rely upon them in your traditions as well. Things like experience, judgment, good professional practices, certification programs, accreditation programs, standardised protocols, proficiency tests, codes of ethics, can't substitute for actual formal evaluation. You know, expressions of confidence, experience, consensus amongst practitioners, they don't cut it. These are inadequate. We need to have formal studies, and we need to have some idea of the performance of individuals and the level of error. Okay, so that's a kind of framework or background to the kinds of fingerprints that I'm going to talk, the history of fingerprints that I'm going to introduce you to in these jurisdictions. Yeah. So I'll start off by saying, I guess they're emerging in the first decade of the 20th century in most of the kind of jurisdictions. As I say, there are cases before the appeals I'm going to talk about, and they get kind of alluded to or suggested or implied, but we don't really have much information about them. And the other thing that is important to say is that the admissibility standards that existed at this time were very different to the kinds of standards that we have in many jurisdictions today in the kind of post-Daubert era. I'll say more about that as well. They were just looking at, whether a person was an expert, maybe whether there was a recognised field, whether it could help the jury, whether the jury could do it themselves. These were the sorts of low-level kind of considerations. The first reported Anglo-American case is Castleton. So this is a fingerprint-only case. So it's interesting, some of these cases have fingerprints and lots of other evidence. This is just fingerprint only. It goes to the Court of Appeal in England. The interesting thing is that it's not an admissibility decision. It's actually a decision about whether fingerprint evidence alone can support criminal proof beyond reasonable doubt. There's one expert, and the court says, yes, it can. Now, it was just, the interesting thing in this case is they found a candle at a place where there'd been a burglary, and the accused's fingerprint was linked to that. Candles are mobile. That's not really discussed in the case. It's an interesting aside. There's a question put to the examiner in this case about whether, put to the defendant in this case about whether he could identify anyone who had the same fingerprint as him. That's an interesting thing in terms of an accusatorial system and the burden of proof. But the other thing that's important to say is that this is almost, there's one sentence missing, but it's not really pertinent, this is the entirety of the decision. So this is the first fingerprint reported decision, and that's it. It's interesting because this case gets cited a lot as authority for the admissibility of latent fingerprint evidence. It's kind of, how did fingerprint evidence come into our courts? It came into courts, and whether there were challenges or not, the value of the challenges, they're pretty weak and they have nothing to do with the sorts of questions that should have been asked, or at least by today's standards, and I can say more about that as well. Now, if we move to the United States, these early cases, the first case that's reported is Jennings, and it is an admissibility case. And if anything, the Americans and their procedures and actually doing things, at least on appearances, which look okay, they're doing better than the other jurisdictions that I've looked at. It's an admissibility challenge, and it's more, I think, a mobilisation by the prosecution and the state, bring 4 or 5, depending on how they're counted, experts together to kind of bolster up this evidence in this murder case. So it's a kind of organised prosecution case. There's a challenge and they're kind of putting forward a strong support for fingerprint evidence. Now, the interesting thing in this case is that Castleton is referred to as is English practice, and so if you look at just some extracts here, the judges say in this case they let the fingerprint evidence in. Experience has shown it to be reliable. It's used in England since 1891 in thousands of cases without error. As Adrian said this morning, we don't know. There's no ground truth to these cases. We don't know whether there's error or not. And the court said in this case that they couldn't refuse to take judicial cognizance of it. The courts couldn't not recognise that it's there, it's kind of in use, it's being used. There are these kind of experts who are recognised by the state, or there are bureaus. How can we not let this evidence in by the standards of the day? So it comes in. And there are analogies to kind of other types of evidence. When the photographs are challenged, then of the fingerprints, they allow fingerprints in, they allow x-rays in, and they allow footprint evidence and eyewitness evidence in, so why wouldn't they allow this evidence in? And it comes in, and all of these cases, it's important to recognise, are about positive identification to the exclusion of all others. Maybe not always an infallible technique at this stage. And then we come to Australia. And Australia is not too different to the United Kingdom. This is interesting, again, because the first 2 cases here in 1910 and 1912 aren't admissibility challenges. They're once again dealing with other things. The first case is dealing with whether the photographs can come in, so that's a bit like Jennings. And the courts say, look, this is a reliable technique, we've had photographs before, it's fine. And in Parker, this is like the first case, Castleton, can fingerprint evidence satisfy proof beyond reasonable doubt? And the court comes up with an emphatic yes, although it's interesting, there's one of the few dissentients in the kind of history of fingerprint evidence, and I'll say more about that. So just to get a sense, in Australia, fingerprint evidence is described as a new science of identification. It's based on experiments. These experiments aren't identified, whether it's a science or not, it's just a claim. And we're also told, and this becomes interesting in terms of understanding our system and its protections, every precaution was taken against any wrongful impression being conveyed to the jury. You know, the safeguards kicked in. We allowed the evidence in, we trusted the trial safeguards. In terms of Parker, the judges are describing fingerprints, and maybe there's an element of kind of truth here, but they're describing fingerprints as much better than eyewitness identification, perhaps the safest of all evidence. And the jury can look at the fingerprints themselves. It's unlike eyewitness identification, and so they're all positive attributes. Now, this is the dissent. The Chief Justice of the second largest or most populous jurisdiction in Australia expressed his doubt. It might be Whiggish to describe him as some kind of hero in retrospect, but you know, he questions about whether it is scientific, whether there's scientific support, and kind of the authority of the claims made by some of the kind of the fathers of latent fingerprint evidence. All of these judges in this particular case, it's very interesting, said the fingerprint evidence could come in, it could come in as identification evidence, but the examiner could not say that the fingerprints are unique, and that was dismissed almost straight away in the next case, and so people make unique claims and still do to this very day. They said it couldn't be supported, these judges, and that's an interesting point that Reisinger has made, that often evidence, scientific evidence comes in with qualifications, and it's very often the qualifications are effaced quickly so that people just make the stronger claims subsequently. Okay, so now I'm going to move on to another snapshot. So that's the origins. Not much really happened, to be honest, between about 1916 and 1998 actually, in terms of challenges or engagement. And it was just a kind of consolidation of fingerprints and fingerprint bureau. That's an interesting observation because this is at a time when there were dramatic changes in how fingerprint evidence was collected and analysed. It was the introduction of electronic databases which made the chances of adventitious matches much higher. So there were real chances of seeing very similar not matches and making mistaken identifications. None of this created even a murmur. I haven't found any case that's ever raised an issue about how the new databases or the new electronic procedures might affect admissibility or the claims that are being made. Anyway, so we come to 1975. This is around about the federal rules of evidence of the United States coming in. Not long after this, there's something like of a tort and civil liability and litigation crisis in the United States. So there's an increasing focus on expert evidence in that jurisdiction. DNA is emerging from the late 1980s, a scientifically based form of identification. Then we have Daubert decided a focus on reliability as a condition of admissibility. That becomes important. Innocence projects showing wrongful convictions through the 90s. In the UK, we have the IRA, Royal Commissions, based on the miscarriages of justice there. And in Australia, we have a series of wrongful convictions like the Dingo Baby case and a series of Royal Commissions there as well. So there's a kind of awareness that forensic science can go wrong and can go terribly wrong in these jurisdictions. And judges are starting to kick expert evidence out in civil proceedings in the United States. But it's not until, and Daubert is 1993, it's not until 1998 that we encounter the first of the kind of first ever maybe serious challenge to latent fingerprint evidence, a kind of methodologically informed challenge. And this is kind of interesting. It's based on, I guess, some scholarly work being done, some attentive scientists, but it's also pre the 2009 intervention by the National Academy of Sciences. So if you look at these cases, Mitchell and Lira Plaza, these are kind of relatively early challenges, 100 years after the first fingerprint evidence is coming in, that people start to ask things about testing, reliability, error rates, these sorts of things. The cases are interesting, but the cases Mitchell and Lira Plaza, let the evidence in. It's let in as positive identification. Where it's Lyra Plaza is an interesting case because I think it's the former Dean of Yale Law School who became a federal judge, heard this, and actually in the first Lyra Plaza admissibility hearing excluded latent fingerprint evidence. I think there are a lot of phone calls and emails sent to him after that, and he had a rehearing and then made a different decision several months later and found it admissible. Same case. In Mitchell, the Daubert criteria are applied to latent fingerprint evidence. So these are the kind of 4 or 5 criteria. In terms of testing, they say, well, uniqueness hasn't been tested, there's not much evidence of it, permanence is okay. In terms of whether fingerprint examiners can make positive identifications, well, there's really not much in the way of formal scientific support for that. So that's kind of weak. But then, we have used fingerprints for 100 years and people have been cross-examining, so there's a kind of implicit test that's been going on by the courts. So maybe it's weak, but we'll consider that. Peer review and publication, they haven't done well. They haven't really published much in the way of scientific research. Error rate, well, we don't know about many errors, so they must be doing pretty well. In terms of standards, fingerprint comparison is not like sciences, where there are kind of rigorous or developed sciences or standards. And in terms of general acceptance, here you have a judge saying, well, all the fingerprint examiners accept it, and so it's generally accepted by the relevant community. And so it passed muster. So there hadn't been any formal validation studies, we didn't know the error rate, and it came in. In Lyra Plaza, the first case where it's excluded, that's an interesting case because even though the criteria, or only one criteria was partially satisfied, and that was general acceptance, but that judge said that fingerprint community wasn't a scientific community, so it's only partially accepted. But then on rehearing, he found that there was a low error rate on proficiency tests, which was subsequently criticised as being very easy. Few known errors in practice. He described fingerprint evidence not as science, but as a technical form of knowledge. And so we could kind of be more relieved that way. Paid a lot of attention to the long history of fingerprint use and some of the founding fathers, and also seemed to be relieved or supported by the fact that English courts admitted latent fingerprint evidence. That's interesting because English courts have a very different admissibility standard, and indeed have almost no admissibility standard for expert evidence. It's described by the Law Commission of England and Wales in 2011 as laissez-faire, just a free-for-all. So America, which has this reliability-based standard in most of its jurisdictions, was relying upon a jurisdiction that had no admissibility standard effectively at all. In terms of England, at this time, this wasn't even really a challenge, it was an appeal. The appeal was abandoned by the defendant, but there'd been some inconsistency about the use of numbers of points by different courts in England. And so they said, actually, we'll do a review of that. And think about this in terms of an appeal. So they went over the history of latent fingerprint evidence in England, and they were happy with the progress that's going on and excellent performance by the police services. But you think about these things. In Castleton, there's no discussion of criteria or standards. In 1924, a 16-point standard is imposed by New Scotland Yard based on a kind of study and some fingerprints by Bertillon, which is subsequently shown to be forged. In 1953, there's a conference and a consensus to adopt 16 points. In 1983, there's a consensus at a conference to adopt 12 points. In 1988, the Home Office asked 2 scientists to review the points standards. They review the point standards and find that there's no scientific, logical, or statistical basis for any of the point systems. And in 1999, knowing all of that, the court says, look, a court could admit a fingerprint on the basis of as few as 8 points, but a judge would probably want more. It's just about how confident the judge feels in terms of the evidence, and also that the historical development has been very positive, and people are working on standards. So we'll let it in. In Australia, again, no real challenge. The only challenge of any moment that I could find is a case called Bennett, and in this case, it was really about whether the Crown, the state, needed to provide actually any images of the fingerprints to the defendant and the markup, the identified points of similarity. And in this case, they hadn't been provided, and the judge in this case and the appeal court in this case said they're not required. This tells you a little bit about how confident courts were in terms of latent fingerprints. And now I want to go to some of the cases that occurred after the NAS and other reports came out. So this is once lawyers started to be aware, and not many of them are aware, of these reports and their implications for the probative value or weight of forensic science evidence. And I'm just going to pick a snapshot of cases. So in the United States, enterprising lawyers take the admissibility point straight away. In federal and state courts, motions to exclude the fingerprint evidence on the basis of there being no validation studies. Remember, testing is a criterion from Daubert. But the courts just say, well, they offer a range of explanations in these cases that these things are widely accepted. There are cases like Mitchell where there were challenges, they were unsuccessful, so we don't need to really worry. We've allowed it in for 100 years. You don't need to have perfect science. They also started to, and this is kind of a very interesting development, impose upon fingerprint examiners this very arbitrary idea, this kind of semi-meaningless notion of qualifying the claim they could make. They could match people, but they had to say the following: to a reasonable degree of certainty in the latent fingerprint examination field, whatever that means. It's not empirically based, it's just a judge saying, say that as well. No reference to error rates or limitations because they weren't available. The courts spend a lot of time saying that these various reports, and this happens following the other reports as well, and it's still going, that these aren't legal documents, that they're not telling the courts what to do, that they don't have implications for the courts, that the people, that the organisations that produce these reports aren't the appropriate communities to be doing these reports, that there should be fingerprint examiners. There's a range of excuses or inoculation strategies being used by these different groups. The other thing that has kind of persisted in relation to these cases and all the cases throughout the kind of periods that I've been looking at is a confidence in the trial and trial safeguards to expose and convey any limitations or problems with latent fingerprint evidence. In England, in the aftermath of the NRC report, no responses. Its defence counsel haven't paid much attention to a scientific report from another jurisdiction. They haven't invoked it in kind of cases or an argument that's kind of interesting. There was a challenge in 2011, makes no reference to the NRC report. It does refer to a Scottish fingerprint inquiry in relation to a mistaken identification there that was going on at the time. But again, that was about standards and problems that might be fixed up at the end of the inquiry, which was ongoing at the time that this appeal was heard. In Smith, it was positive identification from a fingerprint, but what the defence weren't told in the case, and this is kind of typical, you don't get any information about the background, you don't find anything about really what went on through the opaque and very short reports that the fingerprint examiners have historically given, is that originally the fingerprint examiner who identified Smith had deemed the fingerprint insufficient to compare. Once Smith had been charged, he then re-examined the fingerprint and then decided that it was sufficient to compare and identified Smith. That was not disclosed. The defence brought two experts along, and the prosecution went, and this is quite typical for a better resourced prosecution than defence generally, the prosecution challenged the defence fingerprint experts. So we're going to have a very asymmetrical response here, and on appeal, it was seen that some of the procedures and practices and non-disclosure were inappropriate by the state. The only time that the National Research Council report or any of the reports that I put up on the screen earlier have ever appeared in any of the English decisions was in a case of forensic gait analysis. So this is clinical podiatrists identifying people on the basis of looking at CCTV and people's movement in CCTV. And in that case, a scientist, so this is a meta-expert, came in to offer a critique to the court saying, these people have never studied their technique, we don't know if they can do this, they're offering identification or something close, you shouldn't allow this in, they should do studies. And the court said to the meta-expert, you're not a clinical podiatrist. In Australia, we've had one challenge, one serious challenge in fingerprints in the history of fingerprint identification, and that was in 2015. This was a reasonably well-informed challenge in an isolated regional area by a very junior counsel. This was a bit unfortunate in many ways because the fingerprint examiner who was cross-examined claimed that he knew nothing about any of the reports which had kind of revolutionised or shaken the fingerprint kind of field more than anything in its 100-year history. So he basically was cross-examined at length about validation, about the NIST report, about bias, about errors, and he testified, it's an infallible method, the way I use it is infallible, I'm 100% certain, I've never made a mistake, and he rejected the authority of these various reports. His rejection, whether it's genuine or insincere, meant that all of those reports could not come into the court. Those reports were castigated and criticised by the judges who hadn't read them. And so the fingerprint evidence came in, it was a positive identification based on a single fingerprint, and there was no doubt. His evidence was described as not shaken by the court. He'd offered a non-compliant report to begin with, which is interesting, a very short report. And this just kind of confirms that in Australia, we don't have any requirement for reliability as part of admissibility or as part of admissibility decision-making. I should just say one thing, because I omitted to say it in relation to England here, is that at a time when the National Academy of Science, the President's Council of Advisors are telling us to include uncertainty and error rate and limitations in reports. From 2012, the English introduced a system of streamlined forensic reporting. And what that means is that now a defendant will just be handed a one-line statement saying, this fingerprint has been matched to you, and that's all you get. Nothing else, no qualifications, no explanation of what went on. If you want more as a defendant, you have to provide good reasons for why you should be given more information. And then you'll get information specific to those questions and no more. The English are very concerned about money and efficiency these days. Adrian was right. Okay, so I just want to say a little bit about some of the implications of this. I know it's been a very quick and kind of partial exposure, but it's kind of empirical, and it's interesting because a lot of the courts subsequently refer to these early cases as authority for the admissibility and the value or reliability of fingerprints, and yet with almost no exceptions, and no exceptions that I know of, there were no serious cases. There were no cases that asked, does this procedure work, how well, can this individual do it, and how do we know? The only questions that were important to understanding or evaluating fingerprint evidence weren't asked, and that information was never supplied through these procedures. The other thing is that courts are implicated. Courts allowed the evidence in, and fingerprint examiners relied upon the admission as support for their ability and performance. And they still do. They talk about having never made errors in legal cases as proof of their ability. It does say something about their ability, but it doesn't say as much as they would contend. The early cases were generally pre-reliability cases for those jurisdictions that now have reliability, but they're still used as authority even though our standards have changed over time. And even when we started to challenge fingerprint evidence occasionally, as they did in the United States, on the basis of reliability, it was kind of grandfathered, as Cole has observed. They just allowed this evidence to continue basically in the same form, and only some jurisdictions have modified it slightly. Even the absence of scientific studies were excused by these courts with formal reliability standards that concerned with testing. In terms of legal criteria, well, what we can say is that courts have used the wrong criteria, and they still do. You know, courts tend to use these sorts of proxies, these heuristics to understand expertise, but they're misguided. They're individually and in combination. It's not that they don't have any value for understanding expertise, but they're quite limited and potentially misleading. And some of them are bootstrapping, you know, courts relying on something that other courts have allowed in. According to the scientists, there are kind of a series of things which should be done to help us understand the value of a procedure. Courts have never required these things to have been done, and yet they've allowed the evidence in. And we're not talking about some obscure thing, we're talking about something that's used routinely in tens of thousands, of hundreds of thousands, of millions of cases, or comparisons. In terms of trial safeguards, I think you'd have to see these as a failure. So we've relied heavily in our adversarial systems on the trial, let the evidence in, let the judges be gatekeepers, and they've performed poorly. In terms of letting the lawyers manage this, well, prosecutors haven't been very good in terms of disclosure of limitations and problems. Experts haven't been very good in terms of their code of conduct and disclosing problems. Many of the non-scientific fingerprint examiners didn't know about them, to be fair. I think this is a nice example, even though it's very old, of some of the limitations with this kind of strong commitment to trial safeguards, things like cross-examination, directions on the burden or standard of proof, the possibility of rebuttal experts and so forth. In this case, early on, the court assured the public and the defendant in the judgment that they could be reassured because the jury were very carefully directed by the learned judge as to the risk of error to which the evidence of this class is open, and as far as to the conduct of the trial is concerned, every precaution was taken to guard against any wrongful impression being conveyed to the jury. Well, on the basis of what? They had no idea about the performance of these techniques at the time, and yet we're told that the safeguards are working. The jury was properly informed that the defendant had every protection. Maybe by the standards of the day, but it's simply wrong. And these aren't the techniques that are used now. These are techniques where people are identified based on kind of like handheld magnifying glasses on small numbers of points. So in terms of safeguards, if you think about the history of adversarial proceedings, these so-called sceptical environments over more than 100 years, the only change that's been made to the presentation of latent fingerprint evidence that's been required in some US courts is that the fingerprint examiner can positively identify a person, talk in terms of match, but has to say to a reasonable degree of certainty in the fingerprint examination field, as if that's some kind of meaningful qualification to their evidence. I think the other thing to say about trial safeguards, and this is a kind of institutional observation, is that problems with latent fingerprint evidence and many other types of forensic science don't emerge organically out of adversarial proceedings. They come from outside, from scholarly criticism and from the attention of academic and other research scientists. And that, I think, tells you something about the limitations and perhaps failure of adversarialism. And just briefly, to just finish up on these kind of 4 observations. Legal engagement with scientific knowledge. I don't want to suggest at the outset that law should and must on everything defer to the kind of claims of scientists. But this is not like an individual expert where in a court case, this is authoritative, prestigious, august institutions, sort of multidisciplinary groups spending years doing reviews of procedures and all the scientific literature offering advice. So I think at one point, if courts aren't going to accept this advice, it's no good just to say these aren't legal documents. They actually have to have principled reasons for not engaging or accepting these sorts of insights. Law should have mechanisms for formally engaging with these kind of authoritative observations which apply to fingerprint evidence in all of our jurisdictions. Otherwise, it's just fairly arbitrary as to when these sort of challenges come out or get made, and they don't get made very often. There's only a handful over 100 years of tens of thousands of uses in cases. In terms of feedback and legal learning, by not engaging with this kind of snapshot of insight into the performance of courts and the value of latent fingerprint evidence and other types of evidence, courts have failed to learn lessons about their actual performance and abilities. What this kind of evidence and what the National Academy of Science and other reports seem to suggest is that they've performed poorly and they haven't realised that many of their cherished, valorised procedures aren't working well. It's not that they can't work well, it's just in the majority of cases, for whatever reason, a range of social and institutional and resource pressures, they do not work well, and by not looking at outside insight into their own performances, they miss the opportunity to appreciate the frailty. And that's a real loss for the institution, because they don't get much feedback and they don't do much empirical research on their own performances. In terms of other types of forensic science and evidence, well, the example I've given you is something of a success story. It's a kind of partial success story. Fingerprint evidence has turned out to be okay. They can do pretty well. I mean, they've got small error rates and that's good, but they just should disclose that rather than overclaim. But fingerprint evidence is not necessarily like all the other types of forensic sciences that are around. You know, we don't know as much about ballistics, tool marks, handwriting, document, CCTV identification, voice comparison, forensic pathology, neuroscience. There are lots and lots of things that we know very, very little about in terms of validation, and many of these things are allowed in courts routinely, and they're less likely to be as accurate, anywhere near as accurate as fingerprints. And indeed, when PCAST reviewed 7 types of forensic science procedure, they said of bite mark comparisons and microscopic hair comparison, which were admissible in all of our jurisdictions, that they should no longer be used and no more money should be dedicated to trying to refine them. And finally, what might these sorts of observations about both the kind of failure of the courts at one level, the reliance on latent fingerprint evidence say about jurisdictions beyond these jurisdictions that I'm looking at? I think these sorts of things are pretty true from what I've seen in most common law jurisdictions, most social democracies. And I suspect, though I'd like to be corrected and I'd like to hear counterexamples, that they occur in most of your jurisdictions as well. I'm sure most fingerprint examiners still walk into courts or send reports into courts, opaque, short reports that positively identify people with no qualifications. And so what does that say both about the fairness of our procedures, the effectiveness of our procedures, the truth in terms of outcome, and about the possibility of reform? And I'm not saying that all of these cases that kind of guilty people or innocent people have been prosecuted and so forth. What I'm saying is that there will have been errors made. Some of these people will have been innocent and these limitations and problems were never exposed. And for a lot of people, their trials weren't fair. The experts exaggerated the value of their evidence, said more than that could be claimed about the value of fingerprint evidence, and the limitations and problems were never identified or conveyed or understood by the decision makers. And that's really undesirable. And I'll stop there, thank you.
Now the debate is open.
Muchas gracias por la exposición.
Thank you for your presentation. It's been very, very interesting. I really liked it. Great. I have two questions. One, well, in order to reflect my concern about what follows, I have defended, and I think it's one of the points that have to be made in this expert evidence, that there should be empirical information about the way the methods and the techniques function. However, in this case, we have empirical information about that functioning. But even so, or even in this case, the methods and techniques, the reliability of which is very low or questionable, is still being admitted by the courts. So then it is not sufficient to have empirical information. And in the Roman, German, or Germanic tradition, quite often in cases like this, we go a step back and we say, we still don't have empirical information about these methods and techniques. So, but now having this information in common law, it seems that they are still using these methods and techniques. So what do we need? If that empirical information is available, what do we need to stop using those methods that we know already don't have the reliability level that should be demanded? And my second question is especially for clarification. I really am ignorant about the Australian system. And I was very interested to hear that on the one hand, there's like a kind of PowerPoint slide talking about criteria of assessment of the expert evidence, yeah? Such as the fact of them being impartial was there. But then on the other hand, you talk about the jury as well. And I don't know whether in Australia the jury is, I mean, can we know what the jury is assessing when it talks about expert evidence or evidence in general? I didn't get that clear. Because I would be very interested in knowing, in the case of Australia, once the expert's evidence is admitted, what happens regarding the assessment of that expert knowledge? Thank you, and congratulations again.
Thank you very much. I'll say flippantly, no, we don't know anything about the jury, and I'll come back to your second question in a moment. So the first question in relation to this sort of evidence being admissible, just for clarification, I'm saying that latent fingerprint evidence should be admissible and it should be used. It's just that it has an error rate and the value of the evidence is different to the way that it's been historically reported. And that's important if we're hoping to make sense of the evidence. And in many cases that may not matter very much, but in some cases it will, and the fact finder should need to know about it. Just like if you're going to have surgery, you should want to know about the kind of chance that you might actually be maimed or have some kind of undesirable result based on epidemiological studies or meta-analysis of those studies. That should be provided to the decision maker. In our systems, in adversarial systems, there's an assumption that the evidence will be presented in a way that will facilitate or minimally allow the decision maker to act in what might be considered weakly rational, but there's never any supervision or scrutiny of that for the most part because we can't tell. So we want to set up the decision maker to be able to act rationally, to have the information that's important or necessary to make sense of evidence, including expert evidence, that we expect them not to defer, but to be able to understand at some level the expert evidence. But we can't actually assess or determine whether they've done that. Just in terms of the Australian system, it's one of the features there, which has frustrated me a great deal as a kind of evidence commentator, is that we have a system, rules of evidence which were based upon but are not the same as the US federal rules of evidence. A kind of partial codification of evidence rules, but our rule for expert evidence Section 79 resembles the original Rule 702 of the Federal Rules of Evidence. The form is that the opinion has to be based wholly or substantially on specialised knowledge, and the specialised knowledge has to be based on training, study or experience. When it came to understanding specialised knowledge, or scientific, technical and other specialised knowledge in the United States original version, and specialised knowledge is the entirety in our version, American courts, the Supreme Court in Daubert and then reinforced substantially in Kumo, said it's the word knowledge that requires reliability, and the Australian courts cite the definitions from Daubert and Kumo but reject the idea of extraneous ideas like reliability being required as part of the admissibility criteria. So there's a great deal of trust in the Australian system on the trial safeguards because there's almost nothing stopping evidence coming in to the trial in theory. I mean, judges sometimes do exclude evidence, but it's kind of like they're acting almost against the rules of evidence. It's just on a whim or a suspicion that they have. Some judges are perturbed by evidence from time to time, new forms of evidence, but they're not expected to consider the reliability as part of a formal process.
The next one here.
Escuché en una conferencia el 2012 al maestro Tarufo.
I listened in 2012 a conference to Professor Tarufo, and in the United States there was a report of 100 pages saying that forensic evidence were not scientific and could not be considered as evidence, but as something else. I come from Peru, Latin America, and if there is a kidnapping crime which is being assessed, punishment can be 25 years or 35 years, and so the prosecutor will be asking whether the person has been kidnapped in a car. The person says no, and then why do you say it's not so? When the police say there was the fingerprint inside the car. So the question is, with that, we can condemn someone and punish someone for 30 years. So the question would be, how is it that we need to make a graphic expert evidence to have more evidence? Because, you know, in Peru, the idea is not to have a dogma. We talk about protocol as reality. But, I mean, policemen and judges and lawyers are not really trained sometimes. And so, all in all, everything finishes with a dogma, and we can send to prison someone, and we shouldn't. So what should we do with that dactylographic evidence?
Yeah, thank you. The evidence or the expectations or the prescriptions placed on forensic scientists and lawyers in courts are in many ways very onerous. And many of these institutions are not resourced to produce the sorts of research, and the individuals involved, and fingerprint examiners are a good example, especially those without scientific training. They're not in a position to actually undertake scientific research. You can't undertake validation studies if you don't have formal scientific training for the most part. So that makes it very difficult. I should just say also, just in relation to the report you mentioned at the beginning, which I'm not conversant with, that the forensic sciences vary tremendously. I mean, some of them are really quite robust, and some of the kind of traditional or mainstream chemical assays, simple DNA profiling with probabilistic results are very, very good in general. Other types of evidence like, you know, bullet lead comparison, voice comparison on intercepted phone calls, these things are really error prone. So there's a lot of variation, and that's one of the reasons you need formal studies of the various procedures. Otherwise you have no idea about how good they might be. It might seem that it's very plausible. It might seem that an interpreter listening to maybe, say, in Australia it's quite common to have an interpreter translating maybe, say, an Asian language spoken on a voice intercept, and they'll be asked to identify someone. And so they're not necessarily the same skills as being an interpreter, the identification of voices, and there's a lot of slippage there. We don't know about the performance. Courts just allow them to do it for convenience. This might be true of, say, a fingerprint in a car. It seems likely that a person, if they're matched, you know, that whoever deposited the fingerprint was in the car, but we might not know what they were doing in the car. And this is one of the things. So fingerprint examiners can generally talk about match, non-match, but they're not usually in a position to say very much about what a person might have been doing in the car. Were they hostage? Were they not? How long has the fingerprint been there? And so once they stray beyond these areas that have been kind of formally tested, it's speculative. And so that becomes an issue as well. And just the last thing I'll say is in terms of just images, I think there are real risks that I think are largely unrecognised with how risky it is to be using images in courts and allowing lay people access to images. It's not that I want to deprive anyone of any evidence, but images have all sorts of power over us that hasn't really been studied very much and hasn't been considered, certainly by courts, in the traditions that I work in.
Next question.
Buenas tardes, mi nombre es Cindy Reyes.
Good afternoon, I'm Indy Reyes and I work in Colombia. Professor, I have two questions. The first one has to do with something that Professor Carmen Vasquez was telling us about, and the next step would be to review techniques. But I would like you to tell us what is your position, your take regarding the fact on whether the judge has that real possibility of assessing techniques that in the same way as the facts are being proven by that expert opinion, they might not know about because they are not scientists. Then the technique validation would have to depend on scientific communities. Is that so? And then what about countries, as is the case very often in Latin America, where we don't have a solid scientific community that can in fact validate a complex fact? And my second question is about something that has to do with what is and not is complex within a process. I mean, sometimes we don't have a clear border that defines what is a complex fact from one that is not. So do you think that there are facts that are considered complex, such as psychic issues, what happens in electronic media, that maybe should be proven through expert evidence? Thank you.
Thanks, that's a good question. And now it's starting to get harder. So I think it is important for courts to start to consider some of these issues. They historically, because they've been so inattentive to reliability and testing and what these things might require, that they haven't actually started to develop a jurisprudence around these. And it will be a complicated jurisprudence. There aren't easy solutions. It's going to be messy. But I think once we start to undertake studies, courts are going to start to need to make sense of some of the studies. And I think what you'll see is that there must be an expectation that judges, presumably with some kind of advice, and I'll come back to that, are going to have to start to say, you know, these studies provide sufficient ground for admissibility and to make certain claims. And they'll inform the kinds of claims that can be made. Historically, we haven't worried about that. We've let it in and thought that cross-examination could resolve most of those issues, but that can't be right. I think judges are going to have to start to consider things like, you know, what are acceptable error rates in some domains? And maybe it will be, depending on the case, maybe you're less concerned about a high error rate where it's a very strong circumstantial case. Maybe not. I mean, these are questions, policy questions that people need to argue about. So it may be that if the suspect can only have been one of 4 people, you're less concerned about the performance of the technique than if it's just someone from the general community. Then you're much more concerned about kind of validation and accuracy. What are those tribunals or aids going to look like? It's hard to say, but they're going to come in multiple forms. I think that some of the reports that are existing already are starting to kind of provide information. PCAST, the President's Council, actually tried to review the literature and offer the courts insight into what the literature and the existing studies could support at the moment. And that's going to change as well. That's the other thing. And to their credit, many of the forensic scientists are actually doing studies, or scientists are working with them to do studies, and so we're getting a better and clearer idea of the performance. And that will help us to understand or evaluate the evidence over time. Organisations like the Royal Society of London and Edinburgh have started to write short position statements. So I think they wrote one on forensic gait analysis recently, saying that the literature, even though it's been admitted in UK courts, said the literature doesn't support the ability. And so it's going to be probably easier where there's not enough literature to really support any ability. Where it becomes borderline, it'll be harder, and courts are going to, as I say, have to make decisions about that, but they should be informed decisions where they have an idea about what the research is suggesting. As I say, we don't have, in many systems, formal mechanisms where not just a kind of a list of experts that you bring into court for particular cases. I think it's more like you would have a formal body, a government body, offering advice on particular techniques, and that's happening in the United States. They have a range of groups, OSAC groups, under the National Institute of Standards and Technology, and there are other groups around the world doing that sort of thing. There's a European network of forensic science institutes. I'm not sure what you do in countries where the resourcing is not there. One of the important points to take from this is that most of the scientific reviews and most of the scientific advice applies across the board, because science isn't narrowly jurisdictional in relation to these procedures and performances. So it may well be that jurisdictions can rely in general on what's been found in other places, though you would imagine that in Chile or in Spain or wherever, you might actually want to do some validation studies or rigorous proficiency tests on the examiners there to inform how you understand the broader tests that have gone on elsewhere. And in the absence of that, I think you just have to use the indicative research that's available. That's the best we have. And that's what they do in one Australian jurisdiction. They just report on the errors found in American fingerprint examiners, because that's the best we have at the moment. And those guys groan and say we're much better than the Americans, these Australian fingerprint examiners, but there's no evidence of that. And so until they do some studies and find out their own performance, I think just go with the existing empirical evidence.
Any further question?
Hi, I'm Chris Dahlman from Lund University, Sweden. You just said that judges should start considering error rates and combine it with error rates of other pieces of evidence, witness testimonies and whatnot. And I agree completely with that. But in order for that to happen, judges and forensics experts must start to communicate with each other in a way that makes those error rates explicit, right? Forensic experts, fingerprint experts, must communicate them in a way that judges understand. Otherwise, that won't work. And as far as I'm concerned, that's not the case at all at the moment. You started your presentation, your first slide, with, you know, okay, you either have the match or it's inconclusive. And that vocabulary is just completely flawed. Yeah. As I can see from your reaction that you understand what I'm talking about, because, I mean, suppose, for example, that we would have a partial fingerprint. And you would say that, okay, we see here a match between, I mean, the suspect's fingerprints and the partial fingerprint found on the crime scene. But since it's a partial fingerprint only, there is, let's say, a random match probability of 1 in 500 or something. So how would a forensic fingerprint expert communicate that finding? Well, that person would probably say, this is not a match, this is inconclusive, which is silly, because first of all, it is a match. I mean, all the properties that we have on the reference print, we can see on the partial match, so it is a match. The problem is that we have a random match probability that's too low to say that, okay, we can be really sure that it comes from the source. But to say that it's inconclusive is misleading, because it's still, I mean, if it's a random match probability of 1 in 500, that means that we have a likelihood ratio of 500 that actually supports the hypothesis that it comes from the source. So, I mean, any judge who doesn't know anything about forensics or statistics will completely misunderstand that result. So I'd like to hear your reactions to that problem.
Yeah, thank you. I mean, that's been a historical problem. I should say up front that I'm not advocating that we change to a kind of fully Bayesian trial system either. So, and that's partially because lots of evidence in cases is not forensic science. And it becomes very messy when you have these kind of other types of evidence where they're kind of combined with lay witnesses and credibility assessments. You can't put numbers on them in any kind of easy way, and I wouldn't advocate trying to do that or trying to get lay people to kind of work out the difficult Bayesian kind of calculations that are required. Not that people may or may not be doing that formally or informally, that's another debate. And I agree with you. I mean, there's a great loss with fingerprint evidence in just going match, non-match or insufficient, because there's a lot of information that could be passed on. With DNA profiling, you know, we have a partial DNA profile, we still report something that might be 1 in 1,000, and that's probative. That's not as probative as 18 points or loci. And so there's a loss of evidence in the way they proceed. I mean, they just do it for historical reasons because they were defending themselves against kind of real risks. You raised a question about what kind of errors will be applicable, and I think these are difficult decisions. There'll be general studies, and the general studies in many cases won't relate cleanly to the particulars of cases and what the performance has been like in particular cases. And they're just issues that courts are going to have to deal with, but they seem to deal with those issues in civil litigation when it comes to calculating damages for injury or risk. They seem to be done okay in many cases, not always well, but in some cases they're done okay. At least the judges make them explicit and deal with them in most jurisdictions, but not necessarily in the criminal sphere. And communication, yes, I have colleagues who are cognitive scientists who work exactly on communication, and it's a mess. You know, I think this is one of the problems. We're trying to set up a trial system that has assumptions about what's required, but it also assumes that the participants can do the things that they're expected to do, and there's very little evidence that they can do it particularly well, or at least they're much worse at it than we might think they are. And that's kind of unfortunate that judges haven't taken that into consideration, especially my jurisdiction, where everything seems to be corrected by judges giving instructions to juries. So more communication is going to clear up the failure to communicate to begin with, and I don't think that works very well. I think the kind of, my colleague Christy Martiri would say that, you know, as soon as you're talking numbers larger than 10, you've lost the jury. They just can't deal with them. They under or overvalue it in orders of magnitude. Small value, weakly probative value is just goes to negative probative value. They're suspicious of weak evidence. It's just kind of irrational in many ways, or complicated, and so it's a very difficult problem to deal with. Thanks.
I'm afraid we only have a couple of minutes for a... Excuse me? Excuse me? We have only time for a final question by Professor Allen.
So it's a very interesting history, and I certainly applaud all the efforts to make these forensic sciences more reliable. And as you know, and you picked one of the better ones, actually, to present its difficulties. I do wonder, and I don't mean this critically, I think this would be a helpful progress to continue along the lines you and Christian were just discussing, but I wonder if it's a little bit of fiddling while Rome burns. The central problem, it seems to me, the central problem with expert testimony is that it's treated as a separate kind of evidence that's different from all the other evidence ever presented anywhere, and is at odds with the central aspiration to trials, which is that the decision maker can understand evidence, process it, deliberate on it, and in a disinterested and unbiased way, reach whatever conclusion that they reach. If I'm right, that's the central conceptual problem, none of this will affect that. You may get more accurate results, but it's going to be irrational, not rational. So that's just a comment. I've always wondered, since you are such an expert in this field, what your thoughts are on that topic. I mean, my preference, if anybody cares what my preference is, I would present all this stuff to the jury. And I think your colleague is wrong that juries can't understand this. We've never tried systematically to instruct them, to educate them. And the issue isn't whether every juror or every judge, if there's a multi-panel court, understands. It's whether the panel understands. So in any event, I'm not going to go on, but I'm just curious what your thoughts are about this problem.
Yeah, so thanks for that. Again, that's a challenging question. I mean, sure, if I was designing a system, I would not design the system that we've inherited through hundreds of years or thousands of years. Yeah, it's got many kind of frailties. I'm not sure I have a clear answer of what the system would be like, but it would be different in many ways. And so given that we have the systems we have, I can't see anything other than trying to make kind of changes on the basis of the kinds of incremental changes, but also empirically informed changes. Yeah, I don't know if I've seen research that would make me optimistic even with group decision making, though it's not that it's bad, but we need to do more research on that sort of thing to try and facilitate improvements in decision making. And at the end of the day, I'm not enamoured with judicial decision making as opposed to juries, but we should have some kind of rigorous analysis of performances, because it may well be that it is better to have judges and reasons at the end of the day. I don't know, but you know, I understand they're very kind of emotive political issues.
Well, I think we are almost perfectly in time to end this session. So thank you very much, Professor Edmond. Thank you all.